Okay, thank you for your patience. We will resume with the hearing on examining appellate processes and their impact on veterans. And Mr. Cohen, thank you for your patience. In particular, you are now recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank the committee for allowing the National Organization of Veterans Advocates to present its views here. NOVA is a membership organization of more than 300 lawyers and accredited representatives who represent veterans. There were some points that were raised in earlier testimony that I'd like to first deal with before I get to the points I meant to raise. The first one is the court procedure has been referred to as mediation, and that would be incorrect. It is not mediation. It's really a briefing conference, and the goal of that is not to resolve the appeal, but merely to see if there's a reason why it should be remanded. So frequently, cases will go back on a very narrow remand, which does not deal with the issues that were raised on appeal. The second point was there was a question of whether the Federal Circuit should be maintained and is required. I'll call your attention to Part A4 of NOVA's testimony at page 5. The Federal Circuit works to develop and enforce the law. There are 3 cases cited in NOVA's testimony which show how the Federal Circuit works to develop the law and also enforce the law. And the most recent case was the Moore case in February 2009, where the Federal Circuit clarified the duty to assist, which the Veterans Court had wrong. I would like to present the novel idea that nothing is going to change in the system except get worse. The delays, the backlog, the inaccuracy will not change until there's a change in VA culture or the philosophy of the VA. Right now, the VA maintains the position that their highest concern is preventing liars, frauds, and cheats from getting benefits. The concern of the VA rather should be that not one meritorious claim should be denied, and not one combat veteran should be improperly turned away. In the new view, the VA should have in their mind the presumption, the idea that unless proven to the contrary, all claims are meritorious. Sort of like the criminal justice system. We're willing to give a presumption to anyone who's accused to say that they will not be convicted unless there's evidence beyond a reasonable doubt. And we understand that a few guilty people will fall under that presumption, but we're not willing to provide that for our veterans. That's appalling. The VA can use presumptions to grant benefits, grant more benefits, and move them through. People will say there's no money for it. In fact, the VA should be part of the military budget. There are 2 parts of waging a war. One is the direct upfront costs of waging a war, and the other one is fixing what you broke. And when veterans are injured or disabled, they need to get the benefits they're entitled to without regard to the money. That can happen if there's only one budget which is split between the Department of Defense and the VA. It is vital to national security that our veterans should not feel that the government is turning their back on them. I've talked about, in our written testimony, there are 11 points that we've raised to make the system better. I'd like to talk about a few things. One, with respect to the court. The Veterans Court should get class action status. That way, a problem that affects a vast majority of veterans can be fixed all at once. In addition, the court should deal with all issues which are reasonably raised and not send it back on a narrow basis to go back on the hamster wheel. presumptions can be expanded. I mentioned before that the use of presumptions will help the VA move the backlog. One area would be in 1154B. There is a proposal, H.R. 952, to expand that presumption, and that's a good idea. But it should also be expanded to include areas where we know Agent Orange was used, like Cambodia, Thailand, and Laos. The other big presumption is 5107B, the benefit of the doubt. Instead of having the benefit of the doubt where veterans lose their case based on a preponderance of the evidence, it should require clear and convincing evidence for a veteran to lose his case. Sort of like the standard used in workers' comp for many years, a liberality rule, where if the claimant puts in evidence and there's evidence to the contrary, the claimant's evidence wins unless the evidence on the other side is so clear and convincing to the contrary. That's the only way, by use of new presumptions and a new mindset, will this system be fixed. Thank you.
I appreciate all of you being here. We're a little pressed for time. It looks like I have to go back and make another vote. However, I have a couple questions. I think enough time for each one of you to have one. Now, I know that Mr. Preston, I saw in your testimony the AFGE suggests that the BVA be divided into 20 areas of specialization. Can you elaborate a little bit on this proposal? And in the same vein, do you think that this approach would hold true for the regional offices as a way of maybe improving the initial rating decision process?
Yes, I can, Congresswoman. I'm here to address issues pertaining specifically to BVA. In my experience as an attorney at BVA, I've dealt with a lot of complex cases. It takes a fair amount of time for attorneys to get up to speed dealing with the complexity of the cases that they're dealing with. And one idea that a number of activists and other people we represent put forward after much discussion was that we get back to a system such as existed in the past where there were distinct specializations. Now, I'm not here to enumerate what exactly those 20 areas would be, but I mean, we know from just a quick survey of CFR in our experience, so we've got a lot of distinct complex issues. TBI, reproductive system disorders, gunshot wounds, mental conditions, neurological, skin disorders, digestive system, cardiovascular, hearing and visual impairments, and then a whole range of musculoskeletal system problems affecting everything from the shoulder and elbows down to the ankles, including the knees, hand, foot, etc., and then cervical spine and thoracolumbar spine problems. And it is difficult enough for attorneys to gain the expertise to do justice to the claims, but it would be easier and I think more effective. It would lead to greater productivity and concentrate skills and get people up to speed to focus on these areas of specialization, have them work at them for a period of time, and then rotate them out of those areas so that they could acquire other specializations.
Thank you. Mr. Stichman, I have a question. The BVA holds quarterly forums with the VSOs and attorneys in order to have an exchange of ideas. How receptive is the BVA at these meetings when suggestions are made by the advocates to improve the system? Do you have any examples of any of your suggestions that have maybe been implemented by the BVA?
Unfortunately, I haven't attended those sessions personally, so I would have to talk to other people to find out the answer to that question, and I can do that if you wish.
Sure, that'd be great. Mr. Cohen, in your testimony, you noted that the decision review officer at an RO can review and rate an appeal. Do you think that they are the most appropriate line of authority for providing this level of review, or should the claim be automatically sent to the BVA?
I think that should be a matter of choice of the veteran and the veteran's representative. There are certain situations where, for strategy purposes, the veteran would like the case to just go up to the BVA and then go to the court, understanding that it's probably not going to be granted because neither the regional office nor the BVA is going to apply the correct law, and they just want to get a determination. There are other situations where the veteran and the representative might think that the decision review officer review or informal session would cause the regional office to understand the nature of the evidence and grant the claim. So they should have that option.
Okay. One last question, and then I'll think we'll excuse the panel. Mr. Baker, is it fair to the veterans that when they submit what they believe and the DAV service officer believes is evidence in support of the claim, that the VA then decides what is a material fact, assigns an adjudicative value to those facts, and then judges those same facts? Is there a better way to counter the VA or counter VA from acting as a prosecutor and a judge?
If I understand your question regarding material fact, I believe there is. This is, you mentioned the regional office, but I think this is more to do with the court and the board. Okay. In my written testimony, I try to go in depth as to why the benefit of the doubt, when the board takes two equal pieces of evidence and weighs it and makes an opinion or a judgment call as to which one is more probative, which one is not, that is not a finding of material fact. It is an opinion. There are many types of facts, and if words are going to have meaning in the law, we have to apply their legal meaning, and a material fact is not an opinion. Okay. I'm not saying that material facts should not be viewed by the court under the clearly erroneous standard. They should be. All right? The board has asked that remain in place. I agree with that, but an opinion should not be a material fact. As long as it is, the statutory right to the benefit of the doubt can never truly be reviewed by the court as a matter of law, because you have a matter of fact on the clearly erroneous standard standing in a way, putting a big brick wall in the court's way. And I think that's the benchmark of what makes VA great, is that it provides the benefit of the doubt. But at the court level, because of that standard of review, it's also one of the most meaningless laws.
Great. Well, thank you all for your testimony. You're all excused. And before we go to the third panel, I'm going to quickly go vote, and I'll be back.